The final matter to come before the court this morning is Jackie Carpenter versus New Age Logistics LLC et al. I believe. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning and I can keep you apprised of the passage of time. We've read the briefs and are ready to proceed when you are.
May it please the court, counsel. Your Honor, my name is Attorney Jared Hoover. I'm here on behalf today of my client, Jack Carpenter, and his family is behind me. I'd like to reserve 3 minutes rebuttal. Your Honor, if I may, by brief way of factual summary in the background of this case, originally there were a few defendants in this case, and Jack Carpenter is the plaintiff. Appellant in this case. 2 of the defendants, Handle It Inc. and Handle It Manufacturing, have since been dismissed from the case, and New Age Logistics is the only remaining defendant represented by counsel today. The background of that is in March 15, 2013, there was a sale of assets. The purchaser was New Age Logistics, called New Age for short. Handle It was the seller. Prior to that, background by way of the deposition transcript of Garrett Peters, he testified that his company was formed around October of 2012 to purchase film, which would then be supplied to Handle It. Handle It would create these packaging, which would then be sold eventually to GE. That was the purpose of New Age Logistics being formed originally. Handle It, at that time, prior to their ending of business, was engaged in warehousing, that is buying facilities and then leasing the warehousing to customers, and also in what's known as this packaging, creating packaging or thermoforming of packaging for ultimately end users like GE and others. Handle It had financial problems, mentioned, I think, financial disarray by Garrett Peters, who was the president of NAL. And on March 15th of 2013, sold their assets to New Age Logistics. That is, New Age Logistics moved into the position of taking over their product line of selling packaging. And so now they were basically a direct manufacturer and seller of this packaging to GE. So that's kind of the background of the defendants. Again, Handle It and Handle It Manufacturing dismissed. New Age is in. My client, Jack Carpenter, has a history of working for Handle It Inc. prior to New Age's purchase of the assets and their thermoforming and manufacturing part. He had provided services to them in the past prior to March 15, 2013, and engineering and consulting services regarding machines that operate and make these products, and had continued to do that up through March 15, 2013, when Handle It sold its assets to New Age. At that point, my client entered into talks with New Age for providing the same consulting and engineering services to it. To remind the court briefly, the standard for review in this case is de novo on appeal. It's my pleasure to argue this appeal before the court today on behalf of my client. I would like to go into my assignments of error and discuss them briefly. There are 2 assignments of error in my brief. Based on there are several exceptions, but the first exception to the general rule of no successor liability in this case is either the purchaser impliedly or expressly assumed an obligation. In this case, the handle it invoices, I state in my brief, total of 26 invoices amounting to almost $17,000 at the sale. I would argue under the trial court simply got it wrong. Under the rule of express assumption and also implied assumption. Under the first argument of express assumption, in the affidavit of the motion for summary judgment that defendant New Age originally submitted to the court, Garrett Peters, the president of New Age, does not deny that a promise was made to pay invoices. And of course, in the response, the affidavit that my client submitted in response to that motion for summary judgment by New Age, he said that there was a promise made to him to pay, handle its invoices, for New Age to pay those to my client.
As consideration for his continued work, or?
He, at that point, his services were specialized, engineering consulting services were very specialized for those machines, and it was hard for them to find a replacement. So in consideration for him to continue, or in a sense to be rehired by what is, and counsel will point this out, as a new company, a different company owned by someone else, not the same owners. In consideration of offering his services based on the past that he said, you have to promise to pay me the handled invoices, and in addition to paying me for the work I'm going to do now going forward, or otherwise I won't do it. It was simple as that.
And is there testimony or evidence in the record that the promise was made to pay the entire balance of the past invoices?
My client's affidavit would support that, yes. Now that's contested. It's in a sense, he said, she said. So you have a little bit of that, which I would submit to this court as creates a genuine tribal issue. That this should go back and be tried at the trial court level. That alone, I think, is enough for a genuine issue of material fact. That there is dispute. There is authority in this court that says an affidavit, if that's all there is, even a self-supporting affidavit is sufficient to pass test and to bring a case like this back to the trial court for hearing. Beyond that, on the side of implied assumption of the debt, I pointed out to this court in my brief the case Albright in the 8th District that has touched on this implied assumption of a debt, which very few courts have really had a chance to review and talk about. In that case, I think it's helpful because it talks about this idea of equitable assignment and implied assumption of risk, and looking at the conduct of the parties and what the parties did regarding the whole debt. In this case, Handle It was out, New Age came in. New Age President Garrett Peters does not dispute, and his testimony will say this, that all of the Handle It invoices, this almost $17,000 and more, was inputted into their accounting system. And he does not deny that his accounts payable receivable person would have done that, and is marked on those invoices that this was done, posted and entered into their accounting system. And when asked under oath if that meant that these were to be paid, he said yes, the intention was that we would pay these invoices. They never did, and ultimately there's dispute over how much they would agree to pay. And our client.
The intention to pay the invoices, and obviously we'll take a further review of the record, but it sounds like the allegation is they intended to pay them because they needed Mr. Carpenter to continue to provide service, versus they intended to pay them because that was the deal between Handle It and New Age. Am I correct in that recitation of where
I
the
believe
intent was
in the
from?
deposition transcript you will find Garrett Peters saying that. To some extent, to be arguing that in his deposition. I would say that that's contested in his deposition as well. It's a matter of fact. That's why we're here today, and that's why this appeal was brought, because I think there are several issues of material fact. Again, on the implied assumption of the debt, you have not only the invoices inputted, but also the payment. Several of those invoices throughout a period of 4 months before this dispute arises, and I'm contacted by my client and eventually bring the complaint in this case. I would be happy to entertain any questions of this court. I'll reserve, so thank you.
Thank you.
Morning, Your Honors. I'm Kurt Dankwater. I represent New Age, and I'm not going to take 15 minutes, but there are just a few things that I want to point out. and it's in my brief. Mr. Carpenter was an independent person. He was called to repair and do stuff to machinery. He would come and work 1 week, not show up for another month, then come and work 1 week. Each one of these invoices is a separate independent contract. There is no contract where New Age agreed to assume impliedly or expressly the obligations of Hamlet. Hamlet was sued, Hamlet owes the obligation. New Age is a separate company. Under successor liability theory, New Age is not responsible for the Hamlet invoices.
What are we to make of the trial court's entry says on page 5 in 2 instances that there's no evidence that's been presented to the court which provides any detail as to the express assumption. Is not the entry of the evidence that the invoices were entered into the system of New Age plus the testimony regarding why they were done some evidence? Or what am I reading too much into no evidence that's in the trial court's entry where they say the judge says no evidence has been presented which provides any detail about a supposed express assumption of Hamlet's debt, and then the court finds that there's no evidence to support a finding that Null expressly assumed Hamlet's debt. Could not the entry of those invoices be evidence?
No, Your Honor.
Okay.
Mr. Garrett Peters testified that the invoices were inputted just so that they could make payments on them to Mr. Carpenter. That's not evidence that it was an intention to assume either expressly or impliedly those invoices. It was just a mechanism so they could make weekly payments while Mr. Carpenter was helping, assisting New Age.
Well, doesn't that require the court, A, to make credibility determinations, which are not appropriate under summary judgment, and B, doesn't it appear as if the court construed the evidence in a light most favorable to New Age as opposed to Mr. Carpenter, which is what the court was required to do under Civil Rule 56?
I understand your statement there, Your Honor, but my point again is, and I would like to make is, just the idea of inputting them into a computer system is not evidence that they agreed to pay all of them, that New Age agreed to pay all of them. It's just evidence that New Age agreed to pay some of the invoices. What's important, I think, with regard to the evidence is Mr. Carpenter's affidavit. All he wrote was, in response, New Age promised to pay me the whole amount. He doesn't say who, what, where, when, any kind of detail other than the unsupported statement that New Age promised.
Was he deposed?
No, he was not, Your Honor.
Well, that's sort of the purpose of discovery.
I understand.
Is to permit that, and certainly it's the purpose of trial to flesh that out. Here we're at the motion for summary judgment stage.
I understand, but my simple point is, it's not my job to depose Mr. Carpenter to make his case for him. He should have, at the summary judgment stage, and this is what the trial court found, given more detail. Who, what, where, when, how much. He didn't do any of that. He just says, New Age promised to pay me. The other thing I'd like to point out, Your Honors, is that the appellant, Mr. Hoover, cites to the Albright case. That case is clearly distinguishable. It was a 5-year lease agreement. The new company came in, paid for 23 months, and the court found there was an equitable assignment. Here, we have separate independent contracts, and the only evidence that we have that New Age expressly or impliedly assumed whatever the invoices were was that it paid those invoices. I think that's the evidence, Your Honor. The purchase agreement between New Age and Hamlet does not, New Age does not expressly assume any obligations. There was no written contract where New Age expressly assumed. There's no emails, letters, contracts between Mr. Carpenter and New Age where New Age agreed to expressly or impliedly pay these. And I would point out that the case that I cited and the judge cited is that an unsupported self-serving affidavit standing alone was not sufficient to withstand summary judgment. The appellant pointed out the Stone case, Your Honors, but what that case says is that the prior rulings that an unsupported affidavit may never defeat a proper motion for summary judgment, that ruling is overruled. The other important part here is that there is no consideration for these past due obligations, and Mr. Carpenter admits that this wasn't an arm's length transaction where he says that New Age agreed to pay. He says, I threatened. New Age had no choice.
Well, is he the only person? Is there anything in the record that demonstrates he's the only person who could have provided the services? They could have gone elsewhere, possibly?
As Mr. Hoover stated, it's a specialized equipment, specialized equipment, and there aren't a whole lot of Mr. Carpenters out there, as far as I understand. Do you have any other questions?
You did say earlier, I wrote it down, I have the quotes around it, because you said they agreed to pay some of the invoices.
Yes.
Okay. At what point did they agree, or at what point did the New Age decide we're going to stop making payments?
When Mr. Carpenter stopped working for New Age. What they did was they paid him weekly amounts on the past due obligations. So they were going to pay him while he was still working for or providing services to New Age.
There's not a breach of contract element left in this case, is there, as it relates to New Age's agreements with Mr. Carpenter?
I'm not sure.
We only find successor liability.
Right, it's based upon successor liability. There is not a breach of contract. Thank you, Your Honor.
Your Honor, I'd like to respond quickly to the specifics of the promise that was made to pay NAL for NAL to pay handled invoices. In Garrett's affidavit attached to his motion for summary judgment originally, he did say that the time that happened was when New Age purchased some of the assets of Handle It, which would have been March 15, 2013. So we have a date there. The amount, I don't think is in dispute. There is a dispute in the amount, obviously, but Jack says, my client says that it's the full amount. So there are some elements there that are filled in. It's not all unknown, if we should say. I think with the consideration idea, that there's past consideration, there's no consideration, I think perhaps New Age could have found somebody else, but I'll admit, I think that it was very limited. Jack was specialized services. There's nothing in the record that says there was another person out there or anything like that, but I think it could have happened. Jack was in a unique bargaining position to ask that his debts be paid. He has a history, and it was the father of the now president of New Age who was not paying him in the past, who was the president of Handle It. So Jack has concern that he's not going to be paid from someone who's related in the past as well. So there's some of that, I think, going on based on his history. There's more that's not in the record that I won't say, but there's an idea there that there's a reason why at that point there was that would be consideration, be called consideration. It's not the same entity, it's New Age, it's not Handle It. We're talking about the debt of Handle It, not the former debt of New Age.
So your position is that the consideration is his agreement to continue on in a relationship with New Age.
Separate company, yes.
A
separate company and to provide those services. He's asking for this compensation, in a sense, to be paid up. In the sense to, you can think of it as, I want additional compensation for my job. It's a bargaining element. I think it's a fair bargain element based in contract that way. So I understand under this case, the only way to get to the company that has assets now that can pay is through successor liability, and is through the theories of implied or express assumption risk, which I submit to this court. There are genuine issues of material fact that have been presented in my brief that would give credence to my assignments of error, and I ask that this court would consider that. Thank you very much.
Thank you. Thank you both for your presentations this afternoon. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.